Okay, we're going to get started. I think some other people may be still joining us. However, we'll get started because we do have an hour for the presentation. We don't want to run over. Good afternoon and welcome to Garfunkel Wild PC's CLE webinar. It's called the New York Hospital Dilemma, Admitting and Treating Patients with Mental Illness. My name is Colleen Tarpey. I'm a senior attorney here at Garfunkel Wild, and while I'm generally a member of the firm's litigation department, I have been assisting the discharge planning department for a couple of decades now with preparing and attending hearings under the mental hygiene law in court. With me is my friend and colleague, Madeline Zwirling. She's our chair of the Patient Rights and Discharge Planning Practice Group. Maddie brings over a decade of service to our clients in this area, and she's a dedicated and tough advocate for hospitals in all kinds of court proceedings that will be brought under the mental hygiene law. And more than that, is knowledgeable and can advise our clients on the out-of-court day-to-day practicalities of hospitalizing mentally ill patients, as well as a host of other matters like guardianships, medical treatment over objection proceedings, and discharge planning issues of all kinds. We'll talk about a few of those at the back end of the hour. For those of you who are joining us who are attorneys, this webinar qualifies for CLE credit in New York, and there are a couple of things that you need to know about that. The content of the course is acceptable for both newly admitted and experienced attorneys. Please be sure you stay connected to the Zoom until the program concludes at approximately 1 o'clock. Participants are eligible to receive 1 practice credit, and the program will be recorded. For New York CLE attendance verification purposes, course codes announced during the program must be recorded on your attorney affirmation forms and your evaluation form that you'll email back to our firm. Instructions should be in the packet that you received. If you need the packet again, a link to the materials is available in the chat box. And additionally, the slide presentation that Maddie and I are presenting today will be sent out to all of you at the conclusion of our talk. So why are we presenting this today? Well, obviously, mental health issues are at an all-time high. The pandemic is at least partially responsible for the increase in mental health crisis in this country. And given the changing economic and political circumstances in the country, it's increasingly likely that people are experiencing first-time hospitalizations for mental illness or an exacerbation in their symptoms caused by basic stress and disruption of outpatient services. To that end, our hospitals, which are generally already stretched pretty thin in terms of resources and personnel, are seeing an influx in the number of patients presenting with mental health crises. The dilemma, however, is that people who suffer from mental illness are often reluctant to want treatment in an inpatient setting. And that comes from a number of places. That can be the stigma attached to a mental health diagnosis. That can also be just the general disruption caused by an involuntary hospitalization. So between those two places, the need for treatment and people not wanting that treatment, is where our hospitals sit. And so today we hope to touch on how our hospital clients can best assist mentally ill patients, even those who are reluctant to seek treatment. And for that, for the start of our program, I'm going to turn it over to Maddie.
Thank you, Colleen. As Colleen mentioned, we are living in the post-pandemic era, and the pandemic highlighted the need for mental health treatment and the need for care and treatment in a hospital setting. To treat this population, the mentally ill population in a hospital, hospitals need to keep in mind that the mental health system in New York is highly regulated and provides the population with protections and the means to challenge their retentions in court every step of the way. This program will detail every patient in a psychiatric hospital must be assigned a legal status pursuant to Article 9 of the mental hygiene law, and I will get into that in the program. The agenda for this program is set forth in this list. We are going to talk about different statuses of the patients when they're brought to the hospital, treating patients in an inpatient psychiatric hospital, and treatment outside the hospitalization. Once the hospitalization is no longer necessary and a patient is ready for discharge. We will also speak about the court hearings and the process that a hospital must be prepared to go forth and prove why a patient is either in need of retention or in need of treatment, because we have to remember that some of these patients lack capacity to make decisions about treatment. So going forward, let's start off, as Colleen mentioned, that many of the patients in our hospitals start off not being cooperative participants in the treatment process. They don't want to go to the hospital for a number of reasons. They don't want to be treated. They don't want to take medication. They don't believe that they have a mental illness. So how do we begin the process? How do we get these patients, other than those who voluntarily seek treatment, how do we find a way to begin the process of treating the patients? Who actually makes the phone calls for help? Some of that has been in the news because it was discussed by the mayor that the police would be making a determination and taking some of the homeless into the hospital for treatment or observation. So we know that the police have the authority to do that. There is a long list of people who can begin the process of calling EMS and getting the patient to a hospital, in the event that that's necessary. So as this list indicates, you can have a neighbor, a family member, or anyone concerned about a patient can make the call to 911 and just request a well check for a patient, indicating that, someone is suffering symptoms of mental illness, and can somebody come in and just observe the patient and determine whether or not this patient needs to be brought to a hospital. That's pretty obvious, I think. But then you also have mobile crisis team in the community, which is made up of health professionals. They're called, and they will come to a person's home and determine whether or not they need inpatient hospitalization. And they're made up of a team of behavioral health professionals, social workers, nurses, nurse practitioners, and they can make a psychiatric assessment and come to a home and then seek EMS services. The Director of Community Services, or a designee, and what I mean by that is if somebody's living in a supportive housing residence, the director, the head of a housing, can actually direct the removal of a person and ask that that person be brought to either the hospital or a CPAP program, and we'll cover what a CPAP is for those of you. It's an emergency room at a hospital that is dedicated to providing services for mentally ill individuals. And so it's separated from the general ER, emergency departments at the hospital. And so the Director of Community Services or his designee. For those in a shelter, there's people on staff that can contact mobile crisis and seek an ambulance. And then a doctor, a psychiatrist, or a mental health professional also can contact the EMS if a person who they're treating requires such services. Once again, the psychiatrist is an outpatient clinic, police, as I mentioned, or any police officer. And just because they're called, I have to make this clear, just because they're brought to the emergency room or CPAP at a hospital doesn't mean that that person is automatically involuntarily retained in the hospital. There is a step process, and that's what we're going to go through. So the first step is getting that person to be seen in an emergency room setting. Another mechanism for seeking help for a mentally ill person that is suffering symptoms is through a mental hygiene warrant. Many people don't know that this is available. a person can go to court and make an application, a sworn statement, stating that somebody they love, a person they know, a family member, is behaving in such a way that perhaps that they deem that person to be dangerous and should be brought to the court, and further exploration should be made. And so this verified statement is sworn to, and the result of that is a warrant is issued by the court, and a sheriff or a police officer will then go out and serve the warrant and bring that person to the court. And the judge will notice this person, speak with the person, and determine whether or not the patient is likely to result in serious harm if not brought to the hospital for observation. So that's another mechanism to consider if you want to seek help for a loved one in the hospital and you don't want necessarily to be that person who calls the EMS. Now I would like to turn your attention to the time frames and the criteria for inpatient hospitalization. How long can the patient be retained in the hospital? So we've gotten to the point where EMS has been called, or a warrant has been obtained, and that person, the mentally ill or alleged mentally ill person, was brought to the hospital. What happens next? As I said earlier, the mental hygiene or mental health legal system in New York is highly, highly regulated. Anyone practicing in New York, especially on an inpatient setting, must be aware of the different sections and statuses under mental hygiene law for retaining and treating a patient. And listed there are the statuses that every hospital personnel who works in this area must be aware of, the criteria to hold the patient and the number of days that that patient may be retained in the hospital for. So the first listed is the emergency admission, then there's the emergency observation in the CPEP, and then there is the involuntary, which is the 2PC that everyone and most people are very familiar with who work in a hospital setting. Voluntary admission under Section 913, and then there's another admission listed in the statute that most hospitals do not practice under that portion, the informal admission. And I would call to your attention that the Office of Mental Hygiene website has a quick reference overview that lists all of these sections and the requirements that I'm going to just touch upon here. Emergency admission, so in a general hospital. What I mean by that is a general hospital does not have an inpatient psychiatric unit. But there are instances where a person who's experiencing symptoms of mental illness may be brought to an ED at such a hospital. In such an instance, the patient will be seen by a doctor and will then be transferred from the general hospital, providing the staff doctor determines that the patient requires observation and treatment in a hospital with such services. And it will be that patient cannot just walk out of the room then, or walk out of the emergency room. That patient will then be transferred to a hospital that has the facility to treat that patient. And while there are not many general hospitals anymore, and most of the hospitals in New York, and certainly the large systems, all have inpatient psychiatric hospitals, there are some. And there are times when an emergency EMS may have to divert a patient to an ED at a general hospital. So it's good to keep in mind that that does still happen. Emergency admission for immediate observation and care and treatment under Mental Hygiene Law 939. That is the standard for maintaining and observing a patient for 15 days once it has been determined that discharging that patient would result in serious harm, either to that person or to others. I want to call your attention to the word serious harm under 939. It is a higher standard to retain that patient under 939. And when I say a higher standard, everything that we do as attorneys, we do in the shadows of going to court, in the shadows of litigation. And so when I make a statement such as it's a higher standard, that is in case the patient decides to challenge their admission in court. And we'll go forward and talk about that later on, but it's something you have to keep in your mind when you're treating this population. So the criteria for retention under the status is discharging this patient in his present condition would likely pose a serious harm. Serious harm is defined such as homicide, suicide, or an overt threat to commit homicide or a violent act to someone else who can be placed in a fear of serious harm. It's also defined as an ability to see that this patient cannot take care of themselves and they can't meet their needs for clothing, food, shelter, or medical care. They could be in need of certain medical care that it becomes quite obvious that they're not taking care of their needs. This is a 15-day hold, or 15 days, up to 15 days. It's not an automatic 15 days. That's up to the doctors who are treating the patient. There are instances that the patients agree and comply to take their medication and can be safely discharged well before the 15-day period. So I just want to bring that to your attention. And in order to hold a patient, one psychiatrist makes that determination. It's only one certification. So it's for a shorter period of time, but the requirements to hold that person is less than the 2 PC, as you will see going forward. As I said, the 15 days, I got a little ahead of myself, and the patient may always request that court hearing to challenge his or her admission by saying, I am not a danger to myself or others. How are you going to prove that? Here is where I want to just bring up that, as I said, the court process. Everything we do keeping the law always in our minds and the repercussions of not following through. Mental Hygiene Legal Service is made up of skillful attorneys who know this area of law better than, many of us. This is the only area that they practice in. So they know the nuances in and out, and they are assigned to represent the patient and bring any of these patients' concerns to court to challenge the hospital. MHLS is an independent arm of the appellate division, and their goal is to ensure the constitutional due process rights of every individual is protected. And Colleen will go forward and explain exactly what that means to the hospital and what they need to keep in mind going forward. As mentioned earlier, what is a CPEP and how did the CPEP come about? It's good to know that people should understand what the CPEP's role is. CPEP was created, or the regulations creating the Comprehensive Psychiatric Emergency Program, because there was a time that people sought treatment of a mental illness in the emergency rooms of general hospitals. And as we all know, general hospital emergency rooms are overcrowded and usually involve being grouped together and a long period of waiting before patients are seen. And it became clear that there was a need to separate care for the mentally ill or those suffering symptoms of mental illness, and create their own area of the hospital for observation, treatment, and to receive those services that they required. And now, as I said, there are, I believe there are 22, it might be 25 CPAPs in the state of New York as part of hospitals, where if a patient is mentally ill, they could go to a separate area and be seen and treated. And the CPAP can retain the patient for up to 72 hours for observation and treatment before they make a determination if the patient is going to be seen or retained in an inpatient setting. Any of the other information that you need regarding that is contained here. Involuntary admission under 927, also known as the two-physician certification status, or the patient is on a 2PC, as commonly heard. And, you know, everybody knows that a 2PC, a patient, you keep the patient in the hospital 60 days. But there are nuances to the 2PC process that must be respected. If a patient is admitted on an involuntary status and the patient is in need of treatment, and without such treatment, the patient would pose a substantial threat of harm to himself and or others, and his or her judgment is too impaired for the patient to understand that care and treatment is necessary, the patient will be retained under a 2PC certification. It's a two-step process. So there's a difference, and note the difference between the Mental Hygiene Law 927 and Mental Hygiene Law 939. Under 927, criteria is the substantial threat of harm to self or others, and under 939, there is the likelihood of serious harm to self or others. These words may seem like synonyms, but they're not in the course. And they're treated differently. In 939, it's considered a heightened criteria. You must prove it. You must show the overt threat. In 927, you can consider the patient's history. You can consider where the patient is going to live, where the patient is going to seek, or whether or not you believe the patient is going to seek care and treatment in the community, if they have supervision. Those are the type of collateral information that most doctors or treating providers will consider when making the determination to retain the patient under 927. Also, you should know that a patient who's admitted under the 939 and is close to the 15 days, the patient at that point can be converted, again, with two physicians, other than the first physician who made the determination to retain that patient, who make their separate determination that this patient requires additional care and treatment, and then can be converted to a 2PC status. And when you're counting the 2PC status, or the number of days that the patient at that point is being retained, you start with the date of admission, and you include such time as that the patient remained on that emergency 939 status. That's an important matter for the hospitals to keep in mind, the counting of the days that the patient is being retained for. There's a list here of who can start the 2PC process. I don't think I have to read it to you. There are 12 different categories of who may begin or apply for the patient's admission. Important for this webinar is the director of a hospital where the patient is hospitalized. May be the party that what we call will sign the Part A of the process and get the ball rolling. And here you have how it begins. They apply for the patient's involuntary admission by signing Part A, and then the next step is they must be seen by 2 separate doctors who will then determine whether or not, based on the facts of what brought the patient to the hospital, based on the symptoms, they will make a determination if discharging this patient would pose a danger to either this patient or others in the community, and would it be a substantial threat of harm of such danger? In other words, with the patient refusing to care for himself, refusing to acknowledge the need for his food, shelter, clothing, or does this patient have a history of conduct when not in the hospital due to noncompliance with his mental health treatment? Once those 2 certificates are completed and that patient is retained in the hospital, the staff psychiatrist of the inpatient psychiatric hospital where this patient is going to be retained will then examine the patient and confirm that the patient meets the status for involuntary hospitalization. And on the form, you will see that has to be signed and dated as Part B of the 927. And important to point out is that form should not be signed and dated until after the 2 PCs, or the 2 physician certifications, have been signed and dated and timestamped. As mentioned earlier, we have a 60-day hospitalization, a period not to exceed 60 days under a 2 PC. Patients during that time may ask or seek a court hearing, and they can contact mental hygiene legal service attorneys and proceed to court under Mental Hygiene Law 931. They're challenging that they don't meet the criteria. They are not a danger. And a hearing will commence to make that determination, and Colleen will explain the nuances of that hearing. After the 60 days are over, or coming close, or well, I shouldn't say over, or just, we're getting there. The hospital is charged with filing a request for the continued retention of that patient with the court. If the hospital determines this patient requires continued hospitalization and discharge is not an option at the present time, and they don't file for a continued retention, the liability will be on the hospital. If the patient decides that he or she are willing to stay in the hospital, they will consent to the continued discharge, the continued hospitalization and retention. If they do not consent, then another hearing will be held, again based on the criteria of dangerousness, and the hospital can request a retention period at that point of 6 months, and the court has the option of shortening that period. And there will be different factors that would go into that determination of whether or not the patient should be hospitalized for another 6 months. Finally, our last consideration today under the legal status admission, the admissions of the legal status of the patient is a voluntary admission, and that's under Mental Hygiene Law 913. It doesn't sound like that's very onerous, and voluntary means a patient can come and go as they please, but that's not the case. A voluntary patient is somebody who's willing to stay in the hospital when they are admitted, but may decide they're ready to go home prior to when the hospital or the provider feels it's time and a safe discharge can be formulated for that patient. That patient must notify the staff at the hospital of their desire to leave, and then it is the hospital's burden to determine whether or not it's safe for that patient to leave, and if it is not safe, it is the hospital that must file an application for court order. This is a crucial matter for hospitals. If If a patient has signed a voluntary and the patient asks to leave, it's critical that MHLS is notified and that the hospital file an application for court order to retain that patient. And another hearing will take place. Again, whether or not it is safe to discharge that patient.
So Maddie's talked to you about the various legal status statutes under MHL and how these patients end up in the hospital, how long they can be retained for, depending upon what status they're in the hospital under. And what you've heard from Maddie several times now is that the patients are entitled to legal representation by mental hygiene legal services throughout their stay. There are nuances in the statutes that we're not getting into today about when MHLS must be given notice of a patient's admission to the hospital. So they'll be aware at all times that these patients are in your facilities. And the hospital and the patient, under differing circumstances, can both ask the court to hear applications either for the patient's release or for the continued retention of the patient. In addition, there are some hearings that we'll talk about a little bit later in the presentation that deal with treatment and even outpatient treatment. So let's talk quickly about what happens in court and do a quick overview of the court process and the risks associated with missing those mental hygiene law deadlines and also with being ill-prepared to proceed in court. The court process generally, as you've heard, is mostly concerned with a patient's due process rights. These kinds of proceedings under Article 9 frequently take away a patient's liberties, right? It's either their liberty to be free on the street or it's their liberty to refuse treatment that's being taken away. And as a result, the court process is difficult for the hospitals, intentionally so. The court and MHLS are both going to make it difficult for your hospital to meet its burden. And that's as it should be. Clearly long gone are the days of the inpatient hospitalization of the depressed housewife or the slightly rebellious teen. People who are in the acute care setting these days are typically in the throes of a psychiatric crisis. They require acute care. One of the most critical pieces to understand is that these court hearings are not outside of or an adjunct to the treatment team's care of the patient. They are, in fact, part and parcel of care. The reason for that is because without these court processes, your team arguably cannot treat the patient. The patient will either be discharged from the hospital or your team will be powerless to treat them over their objection. And so it means that the treatment team has to consider this court process as a part of the treatment and not separate from it. And when we say that, what we really mean is they need to understand your entire treatment team, from social workers, nurse practitioners, your psychiatrists, even your administrative staff need to understand the deadlines that are involved in terms of applying to court for various kinds of relief. They need to understand those deadlines will vary even depending on what county your hospital is sitting in. The processes will be different depending upon what county your hospital is sitting in. One of my favorite quotes from a court clerk that I heard a long time ago was, Colleen, it's the New York unified court system, not the New York uniform court system. So depending upon which court or which judge you're dealing with, the processes can differ. And it's people like Maddie and I who have the unfortunate experience of having to know those differences. We can help your treatment teams navigate those issues so that we can be sure to get applications before the court in a timely manner and make sure that your treatment team is having the opportunity to treat the patients the way that they deem is appropriate. In addition, treatment teams need to understand their role as fact or expert witnesses before the court, and certainly having an opportunity to prepare their case with someone like Maddie or I to understand which parts of the medical record they want to reference, how they're going to do that in the context of a court hearing and evidentiary rules and all of that other stuff that goes on in court. People are generally not familiar with. Doctors don't go to law school. They go to medical school to treat, not to law school to learn how to appear in court. That's our job, to teach them. And people also need to understand, as they're stepping before the court for these hearings, that the burden of proof is very high on the hospitals. Typically speaking, people are used to seeing, for example, the criminal standard burden of proof, which is beyond a reasonable doubt. Lawyers think of that as saying like 95% of the evidence, 99% of the evidence leans in the direction of guilt or acquittal. For regular civil cases, the standard of proof is a preponderance of the evidence, or what lawyers think of as about 51% of the evidence points in the direction of whatever the outcome of the case will be. These processes under Article 9, although they are civil proceedings, are, however, not at that preponderance of the evidence level. So that means your psychiatrists have to come forward with more than just better than average proof that these people qualify for treatment in the inpatient setting. They need to prove to the court by clear and convincing evidence, or about a 75% threshold, that these patients meet the criteria under the article of the mental hygiene law that they're retained under, or that they require treatment over their objection. So it's a bit of a higher burden, and it's critical for your treatment teams to be trained, really, in how to present in court and understanding the statutory and other deadlines that are a part and parcel, really, of their treatment of this population. Further, people need to understand the role of MHLS. MHLS attorneys are, as Maddie mentioned, very skilled attorneys. They work exclusively with this patient population. It is not, however, their job to care about or to take care of treating the patient. That's your clinician's job. MHLS is there to protect the liberty interests of its clients, and full stop. So oftentimes it may be the case that any objective observer looking at the issue from the outside would say, but this person doesn't belong outside of the hospital. It doesn't matter to MHLS. MHLS is there to protect their liberty interests. And if your hospital does not adequately follow the rules and regulations in the mental hygiene law, you give them the opportunity to get that patient discharged, even if that person is still very ill and very much needs treatment. So certainly Maddie and I can assist anyone who requires it with understanding these court processes and training staff on how to attend these court hearings. And obviously Maddie and I have both handled thousands of these hearings over the course of our careers, so we're more than happy to impart that knowledge. I'm going to turn it back over. Actually, no, I'm sorry. I'm going to just quickly talk about one case in particular. There's a case in New York that really highlights the critical importance of adhering to statutory timeframes. There is a very distinct danger to hospitals if patients fall out of legal status. And the seminal case is the Muncie case. Muncie was a cautionary tale, basically. The patient in Muncie was very ill, was retained in the hospital on an application by the hospital to retain the patient for 3 months. And toward the end of that 3-month status, the hospital forgot to reapply for continued retention. MHLS stepped in, and despite the fact that the patient was quite dangerous and had only a couple of weeks prior attempted to stab a hospital staff member in the neck with a pen, MHLS stepped in on a writ of habeas corpus and asked the court for the release of the patient. The interesting piece about Muncie is that the mental hygiene law has its own writ process. A writ can be applied for anytime somebody is being illegally detained. So you'll often see writ of habeas corpus applications brought by, for example, prisoners in a prison. There is an Article 70 writ of habeas corpus in New York. There is also a mental hygiene law writ of habeas corpus in New York. And initially, the Muncie court was presented with the issue of, well, which one applies? Under the mental hygiene law writ process, the writ application is made, but the court still examines whether or not the patient is a danger to self or others in determining whether or not to release the patient. Under the Article 70 process, however, there is no such inquiry. If the retention is illegal, the patient must be released. So under Muncie, Muncie settled the question of which writ. And the fact was that Mental Hygiene Legal Services had brought the writ application under Article 70, and the court held that the mental hygiene law writ doesn't override Article 70. So under the circumstances in Muncie, the court discharged that patient. That patient, despite his clear dangerousness to self or others, was let out of the hospital. Clearly, this increases potential liability for psychiatrists and hospitals who are responsible for the release of a patient who is either self-injurious or potentially harmful to other people if discharged. So again, Muncie is the cautionary tale of why you really need to keep tight, close tabs on those deadlines. I'm going to turn it back over now to Maddie to talk about what happens with treatment.
So the patient is retained, as I said, but now the patient is refusing treatment. What do? We retain the patient, but we have to treat the patient, and the patient has given you many reasons why he or she is not willing to take the medication. There is a presumption in the law that everyone has capacity to make their own decisions about health care. All of us have that ability to make those decisions. And that presumption of capacity goes with the patient on the inpatient hospital under the status that they have that capacity. They'll come in and tell you, well, I have that right as under the U.S. Constitution as a citizen. I am allowed to refuse treatment. I don't want to take that medication, and you can't give it to me. On the medical floor, in most cases, and we'll talk about this another time, you have that right to turn around and say, I don't want treatment in a situation where a person has to decide whether or not they want to take chemotherapy, let's say. They don't want the side effects that go with it. It's not going to really enhance their life or help them make certain decisions going forward. Most people can make that determination because it's assumed that we all have the ability to weigh our risks and benefits and come up with a determination. As I said, so what is capacity? It is determined that a person can make a reasoned decision about the treatment and can weigh the risks, the benefits, and the alternatives and what will happen to us if we do not accept that treatment that's being proposed to us. Inherent is that treatment has been explained to us. We understand the proposed treatment, and we made an informed decision, informed consent, or informed refusal. Now, on a inpatient psychiatric hospitalization, the healthcare agent who in other medical situations, when a person has lost their capacity to make decisions, and you appoint a healthcare agent, that person can make those decisions. You've assigned someone. In an instance where there's a legal guardian, the same is true. But on a psychiatric treatment, they have no legal authority. That authority is left to the court. So without a court order, the person on an inpatient psychiatric unit who's refusing treatment cannot be treated absent a court order. And there's a process that must proceed in order to get to the point where you're requesting a judge to make that determination on behalf of the hospital. The seminal case is Rivers v. Katz, and I'll just explain what the process is in order to seek treatment over that patient's objection. Of course, to begin with, you have to explain what treatment is being proposed. So a treatment plan must be formulated by the treating psychiatrist, and that treatment plan must take into consideration what medication this patient has taken in the past, what side effects this patient might suffer as a result of this treatment, and must actually make a determination whether or not this treatment is necessary for this patient. He must also, the doctor must weigh the risks and benefits of the treatment and make a determination of whether or not without treatment, this patient can be discharged. So that is what the treating psychiatrist must first do. So they put together a treatment plan, and it's explained, and it must be documented to the patient. And that would be step one. And treatment includes medication, and there are other treatments like ECT. I'm not going to go into right now, but that's another treatment that also requires, when there's a patient is lacking capacity, a court order to administer. So we formulate this treatment plan, and then the process is, once you have the application and you put together the clinical summary and you put together the list of medications, and you also must document that the patient is refusing the treatment. And without such treatment, the patient would be dangerous to himself or others, and the patient is lacking the capacity to make a reasoned decision and has no insight into his illness. Written notice is provided to the patient as well as to MHLS, their attorney. And then part two, another doctor will review the treatment plan, sit down with the patient, meet with that patient, and make a separate determination that this treatment is necessary for the patient's well-being and that the patient is lacking capacity and that a safe discharge cannot be effectuated without this treatment. And again, the second review, as it's called, must be documented that it occurred. MHLS must be there. It is a second doctor, so it's another, like a second opinion, which is what many of us would want when we're given a proposal for treatment. And then at that point, the director of the hospital can then file for an application by order to show cause for treatment of this patient over his or her objection. There will be another court hearing where MHLS will represent the patient. And oftentimes in practice, we will hear that the patient is allergic to medication or can't take that medication, or the side effects of that treatment are definitely, adverse to me. But again, there's a risk-benefit analysis that's done. And from that point, if the benefits of treatment outweigh the risks and the patient lacks the capacity to make a reasoned decision concerning their treatment options, the court will issue an order for the treatment over objection. Critical in all of this is going back to the status requirement. You cannot file for a treatment over objection for a patient that is not being held involuntarily. So that's critical, that that patient must be either held on a 927 or a 939 legal status before going forward for treatment over objection. And once the court order is obtained, it is only effective for the hospitalization for the period of time that the patient is involuntarily held at the hospital. It does not survive discharge. So that's very important. And in addition, there are instances when the patient is held on and involuntarily in the hospital where emergency medication has to be administered. And that is a separate issue, but if the emergency is documented, the patient can receive emergency intramuscular medication.
In fact, we often use, because the emergency standard, the emergency administration of medication is not covered by this particular section of the MHL. You don't require a court order for the emergency administration of psychiatric medication for somebody who is currently physically attacking someone in the unit. Oftentimes, when we go to court, we really want those instances of emergency administration of medications well documented, including the circumstances that led up to that administration of emergency medication, and then also the effect of that medication on the patient, because those circumstances will help us prove dangerousness, for example, if the patient were discharged, and the circumstances will also help us to prove to the court that, for example, they don't suffer any adverse side effects from the medication. They've been administered on an emergency basis. The treatment over objection order is really for patients who are refusing therapeutic levels of medication, so not consenting to take their medication on a daily basis. It's not related to the emergency administration of the medication. We just had a question about that in our questions. So just to clarify. Thank you.
I'm going to just touch upon treatment of minors for mental illness. There are concerns, special concerns about treatment of minors, as you would well imagine there should be. There are occasions and conditions when a mental health practitioner can provide mental health services to a minor voluntarily without parental or guardian consent. However, with the caveat that this is a special area, and the law is pretty clear that when there's a minor, they want the parents to be actively involved, parent or a guardian of that minor. And that's just to bring to your attention, this is a whole other area that must be given ample consideration, because the same laws don't apply when you're dealing with treatment of a minor for mental illness.
So I'm going to quickly talk about, we have just a few minutes left. I'll quickly talk about what happens after discharge and whether or not outpatient treatment can be ordered by a court. So typically speaking, outpatient treatment for mental health is entirely voluntary. Similarly, because many mental health patients also have coexisting issues with drug or substance or alcohol abuse. Those kinds of programs, substance abuse and alcohol addiction treatment programs, are also entirely voluntary, absent some special, maybe court-ordered programs. But typically speaking, once a patient is discharged from the hospital, there's no method to enforce their treatment as an outpatient. And in fact, lots of programs that your team might be trying to set up in a discharge planning conversation will not accept a patient who is not going to voluntarily participate. So the way to assist treating a patient on the outpatient side who is maybe not accepting of outpatient treatment is through an assisted outpatient treatment order. If an adult person has a history of noncompliance with mental health treatment, an assisted outpatient treatment order can mandate that the person comply with outpatient treatment. The law is referred to as Kendra's Law. It was named after a young woman in the late 90s who was pushed onto a subway track by a person who had been in and out of involuntary inpatient hospitalizations for psychiatric condition. And Kendra's Law was designed to provide a means to regulate outpatient care so that the person under the AOT order is required to receive outpatient treatment. And what we typically see in a lot of these instances is that the hospital door is sort of a revolving door when it comes to inpatient psychiatric care. A patient comes in with acute symptoms, your treatment team treats them, gets them psychiatrically stable, discharges them to the community, and without adequate community support and without adequate insight into their illness, they decompensate on the outside because they don't get their services or they don't take their medications, and then they come back into the hospital because their symptoms reappear and they're back in an acute phase. So AOT orders are intended to try to stop that revolving door so that when somebody's on the outside, they can receive mandatory treatment. AOT orders can be applied for, similar to some of these other applications, they can be applied for by a host of different individuals. For our purposes here today, what you should know is that the hospital, the director of the hospital where a person is hospitalized as an inpatient, can apply for an assisted outpatient treatment order. There are very strict criteria, however, that must be met by the patient to have the court issue such an order. And they're listed here. They have to be 18, they have to be suffering from a mental illness, they have to be unlikely to survive safely in the community without supervision. And the most critical piece is really that sort of non-compliance piece, right? This person has gone out in the community after a hospitalization, and that revolving door process happens and they're back in the hospital again within the 36-month period, or in the context of that non-compliance, they've engaged in some sort of self-injurious or harmful behavior toward others. If the court can find that they're unlikely to participate in outpatient treatment without the order and that it's necessary to issue the order to prevent a relapse, the court will issue an assisted outpatient treatment order. The order consists of the entire outpatient treatment regimen that that person's going to follow. It will include their housing, where they're going to live with mom in their own apartment in a supportive housing situation. It will involve what kinds of services they're going to be receiving in the community, whether that's case management services or the assignment of an ACT team, which is a team of behavioral health professionals who are going to follow that patient when they're outside the hospital, check in with them, make sure that they're taking their medication, make sure that they're following up with their appointments. It will also include any partial hospitalizations, mental health clinics that they're going to attend, and it will contain information about which psychiatric medications the patient is going to be required to take on the outside and who's going to administer them. So if it's a monthly injection, who's giving the injection. Further, these orders can also include a substance abuse counseling and treatment component, involving also the taking of random samples to make sure that the person is complying. Finally, if the person who is under an AOT order does not comply, we have the regular court process, right? The hospital applies for it. It's a hearing. The patient is represented by mental hygiene legal services. It's a great tool for making sure that discharged patients who meet the criteria are then supported safely in the community upon their discharge and don't revolve right back into the hospital a couple weeks later. And if the person doesn't comply, it's then possible on the outside of the hospital for a mobile crisis team to go pick up the patient, evaluate them, determine whether or not they need to be readmitted to the hospital for observation or care. So it's a great way for there to be a safety net for this person on the outside of the hospital as an outpatient, and it's a great discharge planning tool for hospitals to have in their back pocket when your psychiatrists know that this person, once they're discharged, is simply not going to follow up with their outpatient regimen. So that's the end of our presentation. I'm going to give you now the CLE code that you'll need, and then Maddie and I will stick around to take some questions if there are any. For those of you seeking to receive New York CLE credit, please write down the following verification code. Your verification code is NYH0502. Again, that's NYH for New York Hospital 0502. Please record the code on your affirmation form and email it along with the evaluation form back to us, following the instructions you received in your registration email. Just very briefly, I'll take some of the questions that we've gotten and I'll pitch them to Maddie. Some of these are, I'm picking these based on them being fairly common scenarios. For example, what happens if a patient refuses to cooperate with providing consent to the hospital to obtain the records that the hospital might need in the event that, for example, you're going for an AOT order and you need evidence of prior hospitalizations to get that?
This is a great question, and it does come up because when patients do not want to comply or do not feel they need the supervision that AOT mandates, they will say, I'm not going to let you release my information or obtain those medical records, and there are HIPAA issues that have to be considered. And in such a case, you can't make a referral without the consent of the patient to the AOT office or the AOT program head in order to begin the process. So what you have to do is go to court and subpoena those records and get a court-ordered subpoena. there's a law that allows the hospital to obtain those medical records if you can show that without these records, there is a real risk to the community, and that risk is greater than this person's right. You overcome the burden to be able to release this person's medical records and then obtain medical records to be able to meet the criteria for AOT. And we can help you with that. We do this all the time, where we go to court and we subpoena and we obtain court orders to allow us to proceed with that.
Thanks. And then what happens if a patient lacks capacity, just generally? This happens all the time with patients who are in psychiatric units. They lack capacity. They might have underlying developmental disabilities or other issues that really they can't engage in safe discharge planning, and they don't have anyone, family or friend or someone in the community, who can assist the hospital with coming up with a safe discharge plan.
This is a problem for the hospitals. This is something that requires legal assistance, and in cases like that, there is the option to file for an Article 81 guardianship in the Supreme Court, where this patient, you have to show that this patient lacks capacity to care for themselves and to make a decision over their property or their person, and you go to court, and if you prevail, a guardian will be appointed. I make the distinction: the hospital will not serve as guardian, but the court will, if the hospital prevails, will go ahead and appoint a guardian to negotiate with the hospital and ensure that this patient finds housing, finds the support that they need in the community. And it is a long process, but we have been successful with these Article 81 guardianships and are there to serve you.
And then, similar to the treatment order that you might obtain psychiatrically, what happens in the event that someone lacks the capacity to consent to needed medical treatment?
That's if that person, again, has no health care proxy in effect, has not appointed an agent to help them make decisions, and they have no one under the Family Health Care Decisions Act that hospital can turn to help with those decisions. It's a similar process where you have to go to court and request permission to treat that patient, because absent capacity, that patient, you have to prove that this patient is lacking capacity to make a decision concerning his or her medical treatment.
We've even had that circumstance come up in the context of a psychiatric admission where the patient was pregnant and was refusing medical treatment for her pregnancy. She was set to deliver during the term of her inpatient psychiatric stay. And so the order to treat her psychiatrically couldn't cover the medical treatment that she would need to deliver a baby she didn't believe she was carrying. She would not consent to deliver. She wouldn't consent to OBGYN helping her to deliver a baby because part of her delusion was that she did not believe that she was pregnant. And so it was necessary for the hospital in that instance to go to court to obtain an order to treat her medically for the delivery, in addition to treating her psychiatrically. So that circumstance does come up even in the context of inpatient psychiatric care, and can also come up just in the medical realm. If there are any other questions, I don't see any other in our chat box. We do thank you for joining us today, and Maddie and I are here and available at any time to answer any other questions that you might have. The presentation materials will be sent out to all of you following the conclusion of our seminar. Maddie, do you have any concluding thoughts or remarks?
It's a very interesting time, and I think that it's very important that everybody be aware of the laws before anything else, before anything happens. Prepare yourselves. It's easy to do if you tune in to what's needed, and we're there to help you. Thanks, Colleen.
Thank you, Maddie. Thank you, everybody, for joining us this afternoon.